Where back-to-back deals break down. Title, records, escrow, and risk allocation. Hello again. This is Forrest Owens. I'm an aviation attorney, a private pilot, and an FAA licensed airframe and power plant mechanic. Now let's turn to the second layer of the analysis, where these transactions actually go wrong in the real world. And the answer is not usually the concept. The answer is execution. The first failure point is title and chain integrity. The FAA recording rules in Part 49 and the registration instructions for Form 8050-1 make clear that if the aircraft is not purchased from the last registered owner, the conveyance chain must be complete from that owner to the applicant. This sounds ministerial. It is not. In a back-to-back transaction, there may be a first bill of sale, a second bill of sale, trust paperwork, payoff letters, lien releases, escrow instructions, and in some cases, international registry or financing files that must align by time, by party name, and by serial number description. If one of these links is wrong, the buyer may have paid for an aircraft that cannot clearly and cleanly be registered or financed on schedule. Remember this, on closing day, speed does not cure a broken chain. The second failure point is the mismatch between the first contract and the second contract. This is where intermediaries get hurt and where buyers often do not realize how exposed they are. If the intermediary agrees to deliver the aircraft to the buyer with fresh inspection status, complete records, certain cosmetic conditions, specific maintenance program enrollment, or a hard closing date, but the intermediary does not secure those same rights against the seller, then the intermediary is selling certainty it does not own or possess. In a piston deal, that can be painful. In a large turbine deal, it can be catastrophic. A large turbine aircraft is often sold with pressure from financing, management commitments, crew planning, tax planning, and charter schedules. If an unexpected discrepancy appears during the pre-purchase inspection, corrosion, incomplete logbooks, an undocumented repair, a damaged thrust reverser history, overdue ADS-B paperwork, engine cycle inconsistency, or an unresolved service difficulty, the intermediary may suddenly discover that the end buyer expects a deliverable that the seller is not contractually required to provide. This is how a spread becomes a lawsuit. The third failure point is records access and maintenance truth. In large turbine aircraft, the records are the asset's legal memory and their economic passport. If the intermediary does not control or have access to these records, it does not have an enforceable right to provide copies or does not understand what records actually show. It may unintentionally make representations that are false or at least incomplete. This risk is not theoretical. It is exactly why sophisticated buyers insist on direct records review, maintenance tracking confirmation, program status confirmation, and clear discrepancy resolution provisions. The fourth failure point is escrow architecture. In a clean two-party deal, escrow is already essential. In a back-to-back deal, escrow becomes the choreographer of the entire transaction. Who receives funds first? The first bill of sale, when is it released? What happens if the seller performs but the buyer does not? What happens if the buyer's all is ready, but the first seller cannot satisfy title conditions? Can escrow use the same incoming funds for both legs of the transaction? And under what written instructions? These are not clerical questions. They determine whether one failed step creates a domino effect across both closings. This is why reputable escrow providers even market specialized handling for back-to-back closings. The structure is common enough that the service ecosystem recognizes it, but it does not mean that it's simple. It means the failure modes are well known. The fifth failure point is regulatory and diligence overlay. AIN's due diligence discussion, republished by the National Aircraft Finance Association, points directly to the modern concern. Back-to-back deals require more scrutiny because fraud, cybercrime, money laundering, and bad actor risk can compound when you introduce extra parties. In a large turbine transaction, that means enhanced diligence on identity, sanction screening, source of funds, beneficial ownership, and the real commercial purpose of the chain. The intermediary may view itself as a market maker, a lender, insurer, export control specialist, or law enforcement may view the same intermediary as a diligence variable. There is also a practical tax and registration overlay. The intermediary short-term ownership may matter for state tax characterization, dealer exemptions, import status, and where and how closing occurs. A structure that works beautifully on a commission spreadsheet can fail badly if no one has thought through whether the intermediary is genuinely taking title, risk, and tax consequences, or is merely papering a pass-through. The sixth failure point, and one which should be obvious but often isn't, is reputation and disclosure. In a sophisticated market, secrecy about price is one thing. Secrecy about role is another. A seller may tolerate an intermediary's margin and still insist on transparency about who is actually buying. A buyer may tolerate an undisclosed spread less readily than people assume, particularly if the buyer later learns that the intermediary lacked control over the first leg, overstated exclusivity, or restricted direct contact for reasons that had more to do with preserving the spread than preserving the transaction. So, what is the practical strategy? Well, to a certain extent, mirror the rights. And that's to a certain extent. If the second agreement promises something, make sure the first agreement allows it. Control the records. Align the title package. Use escrow instructions written for a chained closing, not adapted from a simple one. Confirm exactly who is bearing pre-closing casualty risk, inspection risk, and tax risk in each leg, and force every party to answer the same question in the same words. What must happen before the aircraft can be released, paid for, and registered? In short, most back-to-back aircraft disputes do not arise because the idea is clever. They arise because one party sold certainty before securing control. I'd like you to remember this and take this away. The real danger in a large turbine back-to-back transaction is not the intermediary's profit. It is the intermediary's temptation to promise downstream performance that upstream paper does not support. Thank you for your interest in this topic. This information is provided for informational purposes only and is not to be construed as legal advice. If you have any questions, and they are certainly welcome, please direct them to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.